Welcome to the Center for Nonprofit Resources. I'm Heather Bradley, the director, and I'm excited to be with you again and really excited about to have our guest, Christa Johnson from DHL joining us. You probably recognize Maggie Humphrey. She's my cohort in crime here, collaborating through the Toledo Bar Association to bring these types of high quality impact trainings from the legal perspective. So thank you, Maggie, for that. And today we are also working in collaboration with the Association of Corporate Counsel based out of Central Ohio, which is a new partnership for us. So just a couple of housekeeping things. If you'll notice, this is being recorded. You are welcome to put any questions into the chat box. I'll be moderating, and there will definitely be time at the end of the conversation for open Q&A. Okay, and if anybody has any questions for me or technical problems, I'll be monitoring the Q and let me see, we're in webinar mode. I apologize, the Q&A box. Okay. All right. So Maggie, our introduction, please.
Great. Thank you, Heather. So I'm going to introduce Christa. Christa Johnson is a seasoned employment lawyer with more than 17 years of private practice and in-house counsel experience, managing employment law compliance and employee relations matters. After receiving her BS in business from Cornell University and her MA in higher education from the University of Denver, she worked for 2 years as an assistant director of human resources for Wyndham Hotels before attending the University of Pittsburgh School of Law. In her current role as Associate General Counsel of Employment and Labor for global shipping company DHL, she is responsible for providing advice and counsel to human resources and business partners across the US and the Caribbean regarding issues in all areas of employment law, reviewing and drafting employment policies and employment-related contracts, risk analysis and management of employment litigation, and developing and delivering employment law training programs. So we are thrilled to have Christa here with us, and I will pass it over to you.
Great. Thank you so much, Maggie. I appreciate that. And welcome, everyone. And today we are going to be talking about how to avoid legal minefields as a nonprofit employer. So looking at our agenda, I chose 4 issues that I think are definitely hot button topics, but are also very relevant to the work that you all do. And so the first, we're going to be talking about legal issues with employee selection. Next, proper use of interns and volunteers. Third, we'll be talking about retaliation claims. And fourth, workplace accommodation issues. So I first wanted to do a brief overview of some of the applicable employment laws. The first is our federal Title VII of the Civil Rights Act. This would cover employers with 15 plus employees and protects applicants and employees on the basis of several different protected categories, including race, color, sex, including pregnancy, sexual orientation and gender identity, religion, and national origin. The next federal law is the Americans with Disabilities Act. Again, this covers employers with 15 or more employees, and it protects qualified individuals with a disability. The third law is the Federal Age Discrimination in Employment Act. This covers employers with 20 or more employees and protects applicants and employees who are 40 years of age and older. And then we have the Ohio Fair Employment Practices Law. So this law is covering employers with only 4 or more employees. So it is much more inclusive, and it protects applicants and employees on the basis of several different protected classes that are covered under the above 3 federal laws. So you're looking at race, color, national origin, ancestry, sex, religion, age, disability, and military status. So in the past year, and probably going back further than that, but I think it has had an uptick, is diversity and inclusion. And it may be something that you all have looked at in your organizations for a very long time. But I know that it's definitely having a resurgence, and there's a lot of companies that are finally waking up to how important these issues are. And so this is definitely a priority for a lot of organizations, is diverse hiring. But we need to make sure that we're doing it in the right way, which is the legal way. So what you want to do first is make sure you're casting a wide net in your recruiting. You want to attract diverse candidates, because that's really the only way that you're going to end up hiring diverse candidates and having diversity within your organization. So you want to take some time to examine your website if you have one, whatever marketing materials you have. Are there people from a variety of backgrounds that are representing your company? And if your company's image isn't diverse enough, it could discourage minority candidates from applying. So you need to make sure that you're putting that culture out there for people to see. The next piece of this is interviewing a variety of candidates, because again, like I said, it's impossible to increase diversity if you're not interviewing a wide variety of candidates. So by always having that variety of applicants in the mix, you can assure that everyone is getting a fair shot at the job, and diversity should steadily improve at that point. Again, you may have heard the words, quotas being used, or predictive hiring, those sorts of things, affirmative action plans. And yes, there are, some companies with DHL, we're a federal contractor, so we do have obligations under certain laws to do an affirmative action plan every year, to submit our EEO-1 forms and that sort of thing. So legally, there are steps that we can take that maybe other organizations cannot take. So you just need to be very aware of that and making sure that you are hiring the most qualified person for the job. But again, diversity can come in many different forms. So don't be narrow in how you look at diversity, because it can encompass many different characteristics and qualities. Third, you just want to do an audit or examination of your own company culture. Look at your company from the inside out. Ask your current employees, do a review with your employees about the company culture and any improvements that they think can be made to create a more inclusive, welcoming environment for all. Because even if you get diverse applicants to become employees, they may not want to stick around if the culture isn't as inclusive as they would have thought it would have been. So that's always good to do, to check in with your employees. You do want to make sure that the standards, requirements, and method of hiring are clear, neutral, and unbiased. Again, you still need to be focusing on that piece of it. Avoid any requirements in your jobs, in the qualifications, that could unfairly prejudice a certain group or be prejudiced against a certain group. Be conscious of your employment decisions, ensuring that candidates are considered as a whole and not based on a certain protected trait. Monitor the communications and processes used throughout the company's employment decision processes, recognizing unconscious biases that may be used in making employment decisions. So the whole concept of unconscious bias, you may have heard that term, you may have gone to trainings about that, and I could probably speak for hours just on that one particular issue. And so it's definitely something that you should be looking into and constantly reviewing with yourself and with your colleagues to ensure that that is not coming into play when you're making hiring decisions. And then referrals, which are often a key way to bring on new employees, should also be from diverse employees. I know that we have referral bonuses that we use at DHL in order to hire, but we do need to recognize that that can have some limitations based on the individuals that we have making those referrals. So we need to make sure that we are asking a diverse group of people to be bringing in their friends and people that they know who they think would be a good fit for our company. So when we look at the interview process, I've just, some of these are very common sense, but I did want to point out some of the questions that could be illegal, and then legal questions you can ask that would help you to get the same information. So the interview process should be used to screen applicants based on their skills, their relevant training, and their experience. I do understand that you have a culture in your organizations and that you need people to buy in and fit in within that culture, and that is a piece of this. But again, you need to be very careful about how you screen your applicants to find out if they would be a good fit for the company and not just have skills and experience. So with respect to age, clearly you don't want to ask people how old they are, even the year they're born. A subtle way of doing this is what year they graduated from college. Again, there are some legal questions because there are some bona fide occupational qualifications based on age. For example, pilots. So pilots have to be, they have to retire at 65 years of age. Again, there may be some companies that don't hire anyone who is younger than the age of 18. So at that point, that's a bona fide qualification. It's legitimate for you to be asking questions about age because of those qualifications, and you can do that if you need to. Marital and family status, don't want to be asking about if they're married, if they're pregnant, if they have children, planning on having children. Again, you want to focus exclusively on the qualifications. If the job is going to involve quite a bit of travel or some travel, asking whether they foresee problems with the amount of travel required is a completely legal question. The long hours required, is that going to pose a problem for you? And would they be willing to relocate? If that is a qualification for the role, if that's something that you foresee in the future with that particular role or moving up in the company, again, that's a completely legitimate question to ask. When we look at ethnicity or national origin, you don't want to be asking questions about their ethnicity, where they're from, whether they were born in the United States, because citizenship cannot be considered. You can ask them if they have language abilities that would be helpful. If you need someone who's bilingual, yes, you can ask that question. And you can ask if they are authorized to work in the United States, because that doesn't have anything to do with citizenship. Someone does not have to be a citizen of the United States in order to be employed here. Religion, that is something that is, people need to be careful of, because it is something that's very personal, and we definitely don't want to be getting into a position where we could be accused of discrimination based for that reason. Again, if it is a bona fide occupational qualification, if you are a religious organization and that is a legitimate qualification for the role, then yes, you would be able to ask those types of questions. But outside of that, you need to be very careful about that. Again, a legal question, are you able to work on Saturday evenings, Sunday mornings if necessary? Because that's a qualification or a necessary scheduling issue for that particular job. And then with affiliations, again, the way that things can tend to be in this country right now, divisiveness based on political groups and that sort of thing. We do want to be very careful about the questions we're asking about people's clubs and social organizations and the political parties that they belong to and who they voted for, because that can be a very divisive issue. Okay, I did want to touch briefly upon criminal background checks. Ohio does not currently have a ban the box law for private employers. However, the Equal Employment Opportunity Commission, they issued, and this was, you can see in 2012, so this issue has been around for a while, their enforcement guidance on consideration of arrest and conviction records in employment decisions. So if you're covered by Title VII, then this is something that you need to be aware of. You have to prove that any use of information acquired through your background screen is job related and it did not discriminate against minorities or employees who could adequately perform the job tasks. So these need to be individualized assessments. You need to look at the facts or circumstances surrounding the offense or the conduct, the number of offenses, the age at the time of the conviction, applicant's work history, and rehabilitation efforts. One other item that you want to keep in mind with background checks, not just criminal, but other background checks that you do, is the requirements under the Fair Credit Reporting Act. So there are different adverse action letters and opportunities that you need to give to applicants to make sure that they can rebut or challenge some of the information that you are relying upon in not hiring them. And then finally, looking at social media. I know obviously this is huge right now, and there are decisions being made by hiring managers and hiring departments and recruiters about how much you use social media in terms of reviewing and screening your applicants. So just a couple of items to keep in mind. You want to make sure your candidate research is legal. I think it's always a best practice to give your candidates a heads up that you're going to be reviewing any and all publicly posted social media accounts. If you have an individual or an applicant who is keeping all of their social media accounts private, then they should be kept private, and we shouldn't be asking for passwords to look at that information. I think LinkedIn is a great resource to use, and with the understanding that the candidate is obviously going to make that look as good as possible, similar to their resume and the references they provide. But again, I think it's better to be considering candidates based on that information rather than their Facebook and their Twitter and their Instagram. Because there is a concern and a risk that you're going to find out about a candidate's protected characteristics. And you may be making judgments on them based on pictures that their friends have posted and comments that their friends are making. And it's not necessarily about that person. You want to make sure that if you are doing the social media research, you want to be consistent in your approach. Make sure you conduct the same searches at the same point for every applicant, that you print or save screenshots. If you see something that causes you to question the candidate, if you use an outside company to perform the background check, if you're not doing it yourself, this is where the Fair Credit Reporting Act can come into play. So if you're going to not hire someone based on the information you find out, and there is a company that you've hired to do your background check, you need to adhere to the FCRA. And then you want to treat bad social media information very delicately. So regardless of whether you have a unionized population or not, Section 7 of the National Labor Relations Act will apply to employees and applicants. So this is a provision in the NLRA that talks about being able to talk about work-related incidents, being able to talk about your pay, being able to talk about a bad manager. And so if there is an applicant that you find out is doing this on Facebook, they may be protected. And that communication cannot be used against them in terms of whether you decide to hire them or not. So just be very careful about that. So we're going to move on to our next topic, which is proper use of interns and volunteers. So just quickly, who is an employee? Under Ohio state and federal employment discrimination laws and these other types of laws, employees include, and this is a very general definition, which makes things a little complicated sometimes, people who work full-time, part-time, seasonally, or on a temporary basis and are in an employment relationship with an employer. Okay, what exactly does that mean? So we're going to look a little bit into that in the next couple of slides. It could be volunteers who, if as a result of their service, receive benefits, or those whose volunteer work is required for regular employment or typically leads to regular employment. So you want to be very careful, again, how you treat your volunteers. workers assigned to your nonprofit through a work program. So if there is an early return to work program that you have an association with a corporation, that you will take in their employees who are out due to a work-related injury, again, they're going to be considered employees. And then workers who aren't US citizens, including those who are undocumented. So even undocumented citizens have rights under both Ohio and federal law. So when we look at whether someone is a paid employee or an unpaid intern, I actually just yesterday received an email from one of our recruiters that was asking about, can we have unpaid interns and what do we need to do in order to have an unpaid intern and be compliant with the law? So these issues are constantly coming up this time of year with respect to interns. And you, as nonprofit organizations, can take advantage of your ability to use unpaid interns. So first, you want to evaluate certain factors in the relationship between your organization and the intern. Second, you need to determine which of the parties in the relationship is the primary beneficiary of the work that is being done. You really want that student intern to be the primary beneficiary, not your organization. It really needs to be all about their learning experience and not necessarily whether they're doing some very valuable work for your organization. So 7 factors need to be evaluated. Is there an expectation of compensation? So again, if there is a promise of compensation, it is favorable towards making a determination for employee status. Okay, so you can keep an intern unpaid under certain circumstances. Does the internship provide training that would be similar to that given in an educational environment? Again, this is not the intern providing you with valuable, work, taking over for another employee for the summer. It definitely needs to be educational for them. Is the internship tied to the intern's formal education program by integrated coursework or the receipt of academic credit? It's always better when you do have that formalized relationship with the intern school, so that you can make sure that it is a learning experience for the intern. Does the internship accommodate the intern's academic commitments by corresponding to the academic calendar? So again, you're limiting that internship to those times in which they are not full-time in college, which would be over the summertime. Doesn't mean that you can't have someone being a part-time intern during the school year. It's just one of those factors that would come into play with respect to their unpaid status. Is the internship's duration limited to the period in which the internship provides the intern with beneficial learning? Okay, so if you feel like, hey, there's only 2 months that I can have this intern here and not provide them with substantive work to do, that this is more of a learning experience and the project that we have for them to do is only going to last for 2 months, then you need to think about just having that intern working for that 2-month period of time and not try to make it longer and getting in trouble with respect to the fact that you're not paying them. Does the intern's work complement rather than displace the work of paid employees while providing those educational benefits? And is there an understanding between the intern and the employer that the internship is conducted without entitlement to a paid job at the conclusion of the internship? Again, this doesn't mean that you can't hire them after the internship is over. It just means that in the beginning, that is not a guarantee or a consideration at that point. Even if it is, this is one factor among all of those factors that need to be looked at holistically. Again, all those unique facts and circumstances must be evaluated in order to determine who is the primary beneficiary and the true nature of the relationship. So when we look at volunteers, it is a little bit different than the unpaid internship situation. So looking at these factors are important. So the nature of the entity receiving the services, Nonprofit, not a problem. You all are nonprofit, so you're good to go there. The compensation of any sort, whether it's money, room and board, perks, etc. It's best if there's no compensation, but again, you can look at that. I know with other other organizations I volunteered with, they do have a dinner to say thank you and appreciate the volunteers, but that's the amount of it. So it's really pretty nominal in terms of the benefits that the volunteers would receive. But again, one factor among many. The expectation of benefits in the future. You want to make sure that you're not providing those expectations. Whether the activity is less than a full-time occupation, it is better for your volunteers to just work sporadically or part-time rather than having them there full-time. Again, whether regular employees are displaced, you wouldn't want to say, hey, we can't afford this particular, the receptionist any longer. We're going to get a volunteer to come in or a couple of volunteers to come in and do that work for free rather than us paying a receptionist. You want to be very careful about making those kinds of decisions. And then whether the services are offered freely without pressure or coercion. And finally, whether the services are of the kind typically associated with volunteer work. So when you think about the volunteer work in general, is this the kind of work that someone would do as a volunteer? Again, lot of caution is advised in determining how much to offer to avoid inadvertently causing the worker to be considered an employee when you're talking about giving them a stipend. A lot of times the stipend doesn't even or meet the minimum wage in terms of the amount of hours that person is going to be working, or maybe it's only a little more than minimum wage. If that's the case, then it really is going to be a fairly nominal stipend. And again, that would be fine. Pay that's tied to productivity or the amount of time spent working can be indicative of employment relationship. So if you're paying someone per hour for the time that they're there, again, an employment relationship could be seen. And I do recommend that you use written agreements, separate handbooks for volunteers and interns and employees, and train your management about the limited requirements and responsibilities of the volunteers and interns to make sure there's no mistake about expectations, and as well as for liability protection, because there are a lot of laws, including unemployment, workers' compensation. If you have a volunteer or intern that gets injured on the job, if they're considered an employee based on these different factors, then you're going to be responsible to be paying workers' compensation for them, as well as potentially unemployment when their job ends. So again, you definitely want to be careful about that. Okay, our third issue is retaliation claims. So you may be thinking, why are we talking about retaliation? What's the big deal here? Well, between 2015 and 2020, the percentage of charges filed with the Equal Employment Opportunity Commission that included a retaliation claim have steadily increased from 44.5% to 55.8%. So you're talking about a little more than half of all the charges that get filed include a retaliation claim. And not surprisingly, one form of retaliation claim, which is the whistleblower claim, has seen a significant increase in the year 2020, brought by employees who allege they were retaliated against for reporting concerns related to COVID-19. I was talking before the webinar started about how I've become much more knowledgeable about OSHA this past year because I've had to be involved with retaliation claims in terms of the safe environment that our company was creating, and whether we were complying with all of the different guidance from the CDC and from Ohio OSHA and our federal OSHA. So this has definitely been a huge issue for companies in the past year. Plaintiffs are bringing claims under a variety of whistleblower protection statutes and common law alleging retaliatory discharge based on alleged violations of public policy. So this is something that's a little bit new and different in the past year because of all the different executive ordinances that we have for COVID, for the state of emergency, and whether your employer is, whether you are complying with those laws and with those ordinances. And if someone gets COVID and they end up getting terminated shortly thereafter, or as a result of their absence or something like that, then there potentially could be a claim for retaliation or wrongful termination. So we look at the general definition of retaliation. It's taking adverse action, any kind of adverse action, against employees who participate in protected activity or oppose unlawful employment practices. So looking more at protected activity. So this is when an employee opposes a practice they consider to be illegal, they participate in a proceeding to determine violations of the law, or they engage in other protected activity. And that other protected activity is going to be if they requested an accommodation for a disability or a religious belief, they took FMLA leave or military leave, or they filed a workers' compensation claim, among many other types of protected activity. Then we look at the materially adverse action. So this is any kind of action that's taken to penalize someone or prevent someone from opposing a discriminatory employment practice. So if the employee can say, hey, if I knew that this type of action was going to be taken against me, if I had filed my claim or if I had agreed to be a witness in someone else's complaint, then I never would have gotten involved. If the employee can say that, then they could potentially have a retaliation claim and claim that there was materially adverse action taken against them. So you look at some of these examples, it could be a denial of a promotion or job benefits, a suspension, even a reprimand, a written corrective action that they received. It could even go as far as somebody who used to be invited to team lunches all the time. Now, all of a sudden, they're receiving the cold shoulder. They're being ignored. They're not being invited to team meetings and team social events. That could potentially be a materially adverse action. So you need to be very careful about the treatment of individuals who are engaging in that protected activity. So they also would need to prove that causal connection, okay? So you as the employer would need to have knowledge that they engaged in the protected activity, involvement in the adverse decision, and proximity in time to that decision. So there needs to be that connection that they can prove. You need to contrast facts before the protected activity and after. Is there anything that can cut off that causal connection in terms of the adverse decision or adverse action that is being taken? So in looking at, I've got 10 ways here to avoid a retaliation claim. You want to create and communicate whistleblowing and retaliation policies. You want to make sure that you have those in your handbooks or separately, and that you're communicating that to the employees. Engage in systematic, detailed, and accurate documentation of any performance problems. Create a speak up culture and measure improvement with engagement services. You want to make sure that your employees are bringing issues to your attention and that you are investigating those issues and you're making sure that they're being resolved promptly and properly. Be alert to any potential protected activity. As, like I said, it can assume many, many forms. Take complaints of harassment, discrimination, or other illegal activity seriously. Take all claims of retaliation seriously and investigate thoroughly. Involve appropriate partners in HR, legal, or compliance If you feel like it's necessary to reach out to your legal team internally or an outside counsel that you may use to make sure that you are making the right decisions with respect to that employee, I encourage you to do so because it's really important to get it right. Before taking any adverse action, ensure a consistent approach. Look and see how you've handled those particular misconduct issues in the past with other employees. It may be difficult to find someone who's exactly similarly situated to that employee, but you may be able to find incidents that are at least somewhat similar, and at least in terms of the seriousness. And then you can look and see, hey, are we being consistent? We gave that person a written warning. We're looking to suspend this person for a week. Is that really a consistent approach? Why have we made the decision to take a more serious action against this individual and we didn't against that individual? Again, if you are ever involved in layoffs at all, we can't be using layoffs as a way to get rid of a complaining employee unless the business case is legitimate. You need to make sure that you have kind of all your ducks in a row with respect to documentation as to why that person has been chosen to be laid off. And implement those processes to minimize the risk of disparate punishment for similar conduct. All right. Our final topic is workplace accommodation issues. So we look generally at the Americans with Disabilities Act and Ohio disability law. They're very similar. Ohio really follows pretty much in lockstep with the federal law. So both of these laws are going to prohibit discrimination against both applicants and employees who are qualified individuals with a disability. Okay, so that is a legal term. And what it means is that they are able to perform all the essential functions of the particular job, either with or without a reasonable accommodation. A protected disability is a physical or mental impairment that substantially limits one or more major life activities. Can provide job protection for such individuals in the form of a reasonable accommodation. And notification of the need for an accommodation can either come directly from that employee or that applicant, or it can come indirectly from the employee's doctor or observations of the employee's performance. So we look at that last piece of your observations of that employee as constructive notice. Okay, and that is definitely something you want to keep in mind and be aware of. If that employee's performance has changed within a short period of time, pretty drastically, they were always coming to work on time, they were always there for their entire shift, and now all of a sudden they're late for work, they're leaving early, not performing up to the standard that they had before, that could mean lots of many different things, one of which is a medical condition that is affecting their ability to do their job. And so again, you need to be careful about how you ask the individual about what's going on, but it is important to sit down and have a conversation and give them the space to share or disclose any of those kinds of issues that may be hampering them from doing their job. And then once you are notified in whatever way that individual needs an accommodation, we have an obligation to engage in what's called an interactive discussion. Okay, basically what this means is sitting down, meeting with that employee and having a conversation about what their needs may be. So you need to be able at the end of that to determine whether there is a reasonable accommodation that would allow them to perform the essential functions of their job. And it could take, a period of time. There's a back and forth that happens. There may be medical documentation that you need to review to see exactly what the nature of the issue is. And you have the right under the law to do that, to request that information and to review that information. You want to make sure that you're maintaining the confidentiality of that information once you've received it and keeping it separate from other aspects of their personnel file. But again, that can be helpful to you in making sure that you are reasonably accommodating that employee. So we look at disability inquiries. Yes, this goes back to when we were looking at the hiring issues, but it also includes your current employees. We look at the 3 stages: pre-offer, post-offer, pre-employment, and employment. So when you look at pre-offer, this is the most restrictive. Disability-related questions and medical exams are prohibited, even if they are job-related. Okay, so you cannot ask anyone to even, go get a drug test, which is considered a medical exam, to do a physical capacity exam to see if they can meet the physical requirements of the job. All of that needs to wait until you've made a conditional offer of employment. So you can't ask if they have a disability or the nature of that disability, even if it's apparent. Even if someone comes to the job interview in a wheelchair, or even if they come to the job interview and say, I have an interpreter for sign language or something like that, you cannot ask them any questions about that. Make sure you're not asking about previous workers' compensation claims or past or current medical conditions. Once you've made the offer, things open up a bit in terms of what you are allowed to ask. So it is okay to ask disability-related questions and all right to require medical examinations, as long as all employees in the same job category are subject to the same questions and examinations. Again, you need to be consistent in your approach to handling this issue. So looking at some of the questions when we look at ADA in the age of COVID. Does an employee infected with COVID-19 have a qualifying disability? The answer is probably. Okay, there's not going to be an extensive amount of review for the most part, regardless of the disability or the medical condition as to whether it's a disability or not. There is language from the EEOC that says, look, this is pretty easy. We want you to move on and look at whether there's an accommodation that needs to be made, and don't focus your attention on whether this person has a disability, because the definition is so broad right now under the law. What about an employee who isn't infected but has an underlying disability that may make them more susceptible to having a more serious case of the virus? So in those cases, it will likely be seen as that individual having a qualifying disability. For example, there's a recent case that held that an employee's moderate asthma, which probably on its own would not have qualified as a disability, may qualify when coupled with the COVID-19 pandemic, as it placed the employee at greater risk for serious illness or even death if he were to contract the virus. So keep that in mind when you receive accommodation requests for someone who has an underlying disability, even if they are not currently infected. Can employees ask for an accommodation related to the pandemic if they didn't previously disclose their disability or need an accommodation? Yes, 100%. Under the ADA, employees don't have to request accommodations at any certain point in time. They can have been employed for 10 years and let you know, because of the pandemic or some other situation, that they need an accommodation. Can I get an accommodation if I only need it temporarily until the pandemic is over? Again, the answer is yes. If the employee has a qualifying disability as defined under the law, the employer must consider providing accommodations, even if it's only temporary. And this would go for any medical condition that qualifies as a disability. We can provide temporary accommodations. I did want to touch upon just briefly, because I do think this issue is so incredibly important right now. It is mental health conditions and the ADA. So overall, history, about 47 million adults over the age of 18 in the US report having had any mental health condition during the past year, which represents about 19% of the US. And of these adults, 1.9 million of them live in Ohio. So about 21% of workers, this I found pretty astounding. At the beginning of 2020, they reported having a mental health condition. And at the end of the year, that number jumped to 40%. So this means that psychiatric disability is one of the most common types of disability covered under the ADA. When the employee or applicant discloses a mental health condition and requests an accommodation, the questions to ask here are, how does your disability impact the main tasks of your job? And what do you most need as far as support, equipment, or changes in order to do these main tasks? Don't focus on the fact that they have a mental health condition. Focus on how you can help them do their job with the particular limitations that they may have. So here's a list of some of examples of accommodations with workers with psychiatric disabilities. If they have concentration or distraction issues, managing their treatment and medication, if they have anxiety, take a look at some of these accommodations that you can use. A lot of them are, or most of them are cost-free and don't require all that much intervention. So just be aware of that and empathetic towards those needs. With respect to the psychiatric disabilities, just some pointers here. You want to connect to the business, connect to your employees, and whether you know it or not, about 1 in 5 of your current employees is working with a psychiatric disability. So you want to be able to develop your capacity to respond effectively. With respect to accommodations, will they come forward? Again, you want to make this a work environment that would allow them to feel comfortable coming to you to talk about the issues that they're having. Clear thinking about safety issues. Sometimes we have knee-jerk reactions about safety issues, and people who have psychiatric disabilities try to stay away from that. You definitely want to just focus on that individual and the needs that they have. Managers are going to be your first responders, so you want to make sure you're training them and helping them to understand how to respond. Be a source of sharing and support. Be aware of and careful of harassment and bullying. You may want to do some training on this as well. And building trust is really important for this group of employees. Again, I have some don'ts here, and we talked about them. You don't have to lower performance or production standards. Don't assume individuals with the same disability have the same limitations and need the same accommodation. It needs to be an individualized assessment. Make sure you're not creating a light duty job that doesn't normally exist. If you are providing an accommodation on a temporary basis, make sure it doesn't go for a year and a half, 2 years, and all of a sudden you've created a position for that individual. Don't remove any essential functions, and don't put medical information in personnel files. You do want to recognize reasonable accommodations may require providing a workplace modification. You do want to meet with that employee, update job descriptions to ensure that they're accurate assessment of the essential functions of the job, and make sure you're informing your supervisors and managers about the process you've put in place with respect to reasonable accommodations.
Well, thanks, Christa. If anyone has any questions, I think we can all agree, whoa, that was like, there was so much information in there. Thank you so much. And if you're on this call and you're not aware, I originally started in HR, so I really appreciate the counsel from Christa. If you have any questions, put them in the Q&A box, please. I have a couple. There aren't any questions. So we work a lot, Christa, with nonprofits that are very small. Perhaps there's an ED and maybe a couple of people, and they certainly don't have access to a legal team, or they don't even necessarily have an outside counsel that they go to. So right. Any suggestions if, well, it's really twofold. What does somebody do if they have a complaint but don't feel they can express it? Or what does the ED do if a complaint comes forward? Any suggestions for the smaller groups?
Sure, sure. I would say first, if you feel like you really need legal advice, there are legal aid organizations, I'm sure, in every county. I know there's one that I worked with on a volunteer basis in Columbus, and they are there to help. And I believe that the Bar Association as well can also provide some support that would not cost any money at all, and it would cover a wide range of topics, of legal topics. So I would say, that those resources are definitely available to you from a bunch of different organizations if you feel like you need legal assistance. If there is a complaint that is brought to your attention, what you want to do is first make sure that you spend time with that individual, get their story, get all the details that you can about that particular complaint, what the issue is, take very good notes about that. You can ask the individual to write a statement. So in their own words, to describe exactly what happened and be as detailed as they can about dates, about times, about the particular conduct, what have you, depending upon the issue. And then you would want to start an investigation. So think about the people that complainant may have mentioned in their complaint. Is there somebody who was a witness? Who was the alleged perpetrator of what took place? And again, you would want to then investigate and interview those particular people and try to corroborate the allegations as much as you possibly can.
Mm-hmm. And I'm going to ask Maggie to talk about the TBI services in just a second, but we also know and witness that sometimes the complaints come in about volunteers or clients. So, it's really, HR is a collection of hats, right? People think, oh, HR, but there's all these different things. And when you're a one-person executive director doing all of these things, that can be really tough. So Maggie, can you just spend a few minutes talking about the local services here for us?
Thank you, Christa. That was fantastic. As you mentioned, the Toledo Bar Association does have a pro bono program, and the piece that would be most useful to this group is our Nonprofit Connect. So that is the program that's bringing forward this webinar, and we also have volunteer attorneys who will take on pro bono legal services for nonprofits who qualify. So if you do get yourself into a position where you believe you need legal assistance and your group is unable to afford to hire an attorney, you can reach out to us through our website, through the TBA's website. There's a specific page for Nonprofit Connect, and there's an application right on there where we would collect information about who you are and what kind of legal issue you have, and then we can try to place you with a volunteer attorney. So that's one option. And then we also have resources where we can potentially do just a brief advice call if we don't need full representation. If it's just an issue that you need to run by an attorney, we can facilitate that too.
Yeah, so we are really fortunate in Toledo to have TBA. Please consider them a resource, at least go through the application process and ask for help that way. Another thing, and Christa, you had made one great references to policies and handbooks. Oh, sorry. There are all kinds of things happening here today. Please don't reinvent the wheel. The center has hundreds of templates and checklists and all kinds of things. Now, of course, we can't dispense legal advice because we're not lawyers. But if you wanted a sample harassment policy, or I don't know what, like there's all kinds of things out there. So you can submit an online TA request on our website. It'll take you 3 minutes or less to fill it out. If we can't find it, we'll try and research it for you. So that's another option. So,
right. I would say, just piggybacking on that, there are a lot of times I just do Google searches for forms and that sort of thing. And it's amazing what you can find just through a Google search. There's a company called eyesight.com and it's isight.com. And they have a very expensive software system that does investigation type of stuff. But you don't have to engage them. What's great is you go to their website and they have a ton of free resources there that can give you investigation plans and just anything dealing with investigations, questions to ask, trainings, webinars on there about training or about investigations. So, there's a lot of resources that you can find online as well.
And I understand it can seem like you're lonely and you're out there on your own, and you're really not. So just reach out if you need help. And I've worked with other great lawyers just like Christa, and they've drilled it into my head that the employee handbook is a legal document. So we really do need to be mindful when we're constructing those. So I do think templates are helpful, but for example, if you grab a template out of California, we were talking about this earlier, the rules and requirements in California are very different from Ohio. So again, you can reach out and ask for help. I don't see any questions. Any other last call for any Q&As?
I have a question for you, Christa.
Yeah.
And I think this would probably be useful for some of our smaller nonprofits, but really for anyone. You mentioned that when you were talking about posting a position or creating a job description, to not make requirements that could unfairly prejudice certain groups. What kind of requirements are you thinking of that would, if you're saying you're trying to create a job posting, what could be something that would unfairly prejudice certain groups?
Well, I think the first thing that pops into my mind are physical requirements. Okay, so we just want to be very careful, and I'm constantly counseling the managers that work in our warehouses, because their general job description talks about the physical requirements of being able to lift 70 pounds or more. And I'm always going back to them and saying, okay, guys, how often are the packages and the shipments that come in at this particular location 70 pounds or more? And of course, a lot of my responses I'm getting are, well, probably none. They're more around the 30 to 40 pound range or less. I said, okay, well, we can't advertise for a job saying that the physical requirement is this much when the actual job requirement is only going to be this much. So you just need to be aware of that, because that can definitely filter out someone who may have some type of medical condition or disability that wouldn't allow them to be able to do that. We also, I've seen in the past where you're talking about English only requirements. I think those are really going by the wayside, thank goodness, unless it's definitely a bona fide, legitimate requirement for the job. But those types of things you can't put out there as has to be, or you have to be able to speak English in order to do this job. And so somebody who sees that aren't going to be thinking, well, I don't speak English all that well. I do speak it, but it's broken, so they probably wouldn't hire me for this job. And so they're not even going to take that step and apply, even though they would likely be qualified for it, even though they have broken English or English as a second language.
That makes sense.
Great question. Yeah. Well, I want to thank all of you for joining us for this episode of C4NPR Chat. As we usually do, we will be creating a blog post. There'll be a link to the video replay. I'm even thinking, what board members might need to watch that interview piece, just to make sure if they're involved in interviewing that we're not asking any questions that could get us in trouble. And we will also put a link to the PowerPoint slides. So once again, I want to thank Toledo Bar Association and Maggie Humphrey for helping make this possible. Also the ACC chapter in Central Ohio, and of course, Christa Johnson of DHL for taking the time and sharing her expertise. Thank you so much for joining us.
Thank you as well, Heather and Brett. Thank you.
Thank you.